Hello, everyone, and thank you for joining Mayor Brown's webinar today, Benefits and Compensation University, Developments and Key Issues in U.S. Employment Law. This is the final webinar in our Benefits and Compensation University 2022 series. My name is Marcia Goodman, and I'm a partner in Mayor Brown's employment litigation and counseling practice based in Chicago with a national and global practice. Joining me today are Mary Tony Kane and Kim Leffert, also members of the firm's employment litigation and counseling practice. Scott Perlman, a member of Mayor Brown's antitrust and competition practice, is also joining us today to bring together these increasingly related legal worlds. Before we begin, I'd like to cover a few administrative matters. If you are applying for CLE credit, we will provide the usual alphanumeric code during the presentation. Please record this code on the CLE affirmation form, which can be found in the connection details email we sent yesterday. The form will also be emailed to you after the program. The email will include links to a recording of today's program and an evaluation form. The evaluation form can be found in the same file as the CLE form. Even if you do not apply for CLE credit, please complete the evaluation so that we may continue to provide you with meaningful content. If you have any questions during the presentation, I invite you to let us know through the Q&A feature on the bottom of the screen, where you can type your question into the Q&A box. We will do our best to address questions live or after today's program. With that said, let's begin. So could you go back to the table of contents slide for a minute? Right, so the topics we're talking about today, I just want to give you a preview, are first, the current non-compete legal landscape. Second, arbitration, and in particular, considerations in mandatory arbitration clauses. Third, antitrust is the new HR skill, and you'll see what that's all about. And fourth, pay transparency laws on the rise. So now please go to the first slide. Now the next slide. All right. So as you all know, generally, there's been a sea change in the legal landscape regarding non-competes and restrictive covenants over the last few years. Historically, restrictive covenants were governed only by state common law, and most jurisdictions enforced covenants not to compete so long as there was a legitimate business interest for the restriction, and so long as the restriction was reasonable in time, geography, and substance. Now, there are 29 states that have statutes that govern the enforceability of restrictive covenants, even going beyond non-competes, and also the District of Columbia. So what we're going to do today is attempt to fix in your mind the big picture of what the law is now on restrictive covenants and non-competes, so that you'll be able to look at your own company's practices strategically and think about how you want to deal with these going forward. Next slide, please. So when we talk about restrictive covenants, and I'm going to go back and forth today between restrictive covenants, non-competes, but et cetera, et cetera. But restrictive covenants cover agreements not to compete, agreements not to solicit, and sometimes the non-disclosure confidentiality agreements are even viewed as restrictive covenants that have to be scrutinized. So we'll talk about various of these as we go along today. Next slide, please. So the first, I shouldn't say the first departure, but a notable departure from the state common law approach occurred in 2021 when President Biden issued an executive order on promoting competition. And in the executive order, the president directed or encouraged the FTC to exercise its statutory rulemaking authority to restrict the use of non-compete clauses and other similar clauses that he felt or the government felt were being used unfairly to limit worker mobility. And the question is, well, why do they care? And the reason is because there are a series of economic studies that make the case that restricting worker mobility also restricts worker wages and restricts employees' ability to have a productive and satisfying career and to make a living wage. So this is really a policy approach. Next slide, please. So the executive order encouraged everyone in the government to look at this issue. So the FTC held a number of hearings and in fact may be continuing to hold hearings. I was actually asked to speak at one, but the hearings really were focused on how can we best limit non-compete. So I was a salmon swimming upstream in that hearing, but it was quite interesting and enlightening. Next slide, please. So then in 2021, something else happened, which was that two bills were introduced in Congress that would also restrict non-compete agreements on a national basis. The Federal Freedom to Compete Act would have banned non-competes entirely for most non-exempt workers. And the Workforce Mobility Act would actually ban all non-competes unless there was a sale of a business. Now, neither of these have passed, neither of them have failed. They remain pending, but as the current legislative session winds down, it seems less likely that they'll be passed, but depending on what happens in the election, they may come back. But even Republican senators have sponsored some of these, so they may come back regardless of what happens in the election. Next slide, please. So in 2022, just a couple of months ago, the antitrust enforcers got into the act and the FTC entered into a joint MOU with the NLRB, and so did the DOJ. And, we'll hear more from Kim and Scott about what the antitrust enforcers are looking for, but certainly they're looking for information. So if the NLRB, which has the right to demand information if an unfair labor practice charge is filed, so if the NLRB collects information that the antitrust enforcers may find useful, you can assume that information is going over to the DOJ or the FTC. And theoretically, they also want to engage in training, education, and outreach. We'll see. Next slide, please. So another thing that happened, and really beneath the notice of most employment lawyers, was that in 2021, the Uniform Law Commission approved a model state law that would not prohibit but regulate restrictive covenant employment agreements. And that model law is named the Uniform Restrictive Employment Agreement Act. And of course, as happens with a model law, it actually doesn't mean anything until a legislature adopts it. Well, mid-year 2022, the Colorado legislature passed a law that was modeled on this Uniform Restrictive Employment Agreement Act. And we'll talk about that later in this section, but that Colorado law modeled on the model law came into effect in August. Next slide, please. So here are some of the elements of this model law, but we'll talk about those more as we talk about actual laws that exist in different states at the moment. Next slide, please. So, it's easy to say 29 states, but I kept asking, what are these states? I can't memorize them all, but I wanted to show them to you on a slide. in bold so that you could look at them all and, see that 29 states is a lot. And it includes, of course, California, which has always prohibited, not always, but for a long time, prohibited non-competes. It includes Illinois. It includes the District of Columbia. It does not include New York, which is interesting. So possibly that may be coming. But it includes a lot of states where I believe a lot of our listeners have employees. So these are not something that you can ignore. As we go on, I'll tell you how to deal with them. Next slide, please. So it's here, what I want to do is give you an idea without going through each law. What do they say? So they run the gamut. So it's really a minority of jurisdictions, California, North Dakota, and Oklahoma at the moment, that make restrictive covenants largely unenforceable. That we may be going in that direction, we may not, but that's where we are now. Then in the new state laws, some apply to existing agreements, some only apply to new agreements that are entered into after the statute comes into effect. There's a lot of variation, and one important thing is that under the common law, there, of course, was not a provision that penalized employers for having an unenforceable non-compete. They just couldn't enforce it. But under these new laws, there are penalties for employers and incentives for employees to actually bring cases to challenge the situation. So that will certainly change the landscape for employers. Next slide, please. So one area that a lot of the laws try to work on is protecting lower wage employees by prohibiting non-competes for employees who don't make more than a certain threshold. And as you can see from the Maine, Maryland, Massachusetts, et cetera, these started out to be $50,000, $60,000, $30,000, all non-exempt employees. But in 2022, we have Washington, D.C. and Colorado. And Colorado's threshold is, we'll talk about these in more detail later, but both of those impose thresholds that are over $100,000. So for any employee that makes less than that threshold, the non-compete is entirely prohibited. So that's something to think about. Next slide. Another interesting trend, which perhaps takes some suggestion from the common law cases, is that some of the laws require that the employer compensate the employee for the period of the non-compete. And it seems that 50% is the level that's most common, but New Jersey is considering a law that would require employers to pay 100% during the non-compete period. And there also are a number of the laws that prohibit enforcement of a non-compete against an employee who's terminated without cause. And the theory there is, well, you didn't need this person. Why are you restricting them from working somewhere else? And that is an important part of the common law in New York and some other states. But it's interesting to see that making its way into the statutes. Next slide. So we'll just go quickly through 3 of the laws that came into effect this year. So the Washington, D.C. law is effective October 1st, 2022. Interestingly, Washington, D.C. first passed a law that would prohibit all non-competes similar to California. But the effective date of that law kept being pushed out because it was very controversial. And so then this summer, the Washington, D.C. passed a new law called a clarification, which did allow certain non-competes, but imposed a lot of requirements. So the income threshold is $150,000 for most employees and $250,000 for licensed physicians. It has limits on moonlighting policies, and it has what looks like a bit like an exception for restrictions that are tied to long-term incentive comp. Next slide. So Illinois' law is kind of old now because it became effective January 1st, 2022, but it actually is quite typical of some of the laws that are being considered now. So it has limitations, it has compensation threshold, it requires advance notice to the employee, it requires consideration, it requires that the employee be advised to consult an attorney. An interesting element that is present in some statutes and not others is the Illinois statute specifically permits courts to reform the covenant. So that's actually a hopeful provision. It does require that the original provision be drafted in good faith and not be ridiculously overbroad. Next slide. So Colorado, we talked about that. It came into effect in August 2022. It applies on a prospective basis. It prohibits non-competes unless the person's salary is $101,500, which increases over time, requires advance notice. Another interesting thing when you're trying to come up with a national policy, it mandates the use of Colorado law and venue where the employee worked in and was terminated in Colorado. And that's interesting because California, for instance, cares about where the employee is working when you're attempting to enforce the covenant too, and apparently Colorado doesn't care about that. Next slide. So we're almost at the end here, and I wanted to highlight a couple of areas that maybe are a little less obvious. So most states still do allow non-disclosure or confidentiality agreements that protect, of course, trade secrets and proprietary or confidential information. And usually the limitations on those are much looser than restricted than non-compete restrictions. But it's important to bear in mind, and this again will tie into Scott's discussion, that it's illegal under the labor laws to restrict employees from talking about their salaries and wages, and that is so that they can complain that they've been discriminated against and so that they can know what's out there in terms of what are the options for their own compensation. All right, let's go to the next slide. So I'm going to let's see, sorry, have some notes here. So we have some tips, and we'll get the slides after the presentation, and so I think it may be better to read the tips then. But what I'd like to suggest to you is important is that you that as a company you take a strategic look at your non-competes or your restrictive covenants, and often those come into effect in a kind of form or boilerplate manner without anybody paying a lot of attention to it. And because of all these limitations, what I'm going to say is that if you want to ever use them, this is a good time to pay attention to your the language of your agreements and to what you want them to do. And some of the ways you can pay attention to that are by thinking, why are these important to you? How would you use them? And at a sort of more micro level, what would you do if there was a raid on your important employees and one of your competitors tried to take them away? So we're obviously happy to discuss these points with you as you think about them. They're very different from company to company, but that's where we'd like to leave you on this.
Thank you, Marcia. We're going to talk a little bit right now about arbitration clauses. And arbitration clauses are like non-competes, sometimes those kind of agreements that get put in, or provisions that get put into agreements without really thinking very much about them. But we do encourage you to evaluate your arbitration clauses. Next slide, please. So the real issue this summer, the Supreme Court issued a very interesting ruling in a series of rulings on arbitration clauses. And to give you a little background, way back in 2011, the Supreme Court first ruled and determined in the AT&T Mobility versus Concepcion case, and then later in an Epic Systems versus Lewis case in 2018, the court made very clear that parties agreeing to resolve their disputes via arbitration agreements are fully enforceable under the Federal Arbitration Act. And both of those decisions, AT&T Mobility and Epic Systems, both made clear, but the court said, listen, the FAA requires courts to rigorously enforce these arbitration agreements according to their terms, which can include terms for individualized provisions, and they preempt any state laws that interfere with that kind of enforcement. And so what happened, how we get to what's called the Viking River Cruises case is, of course, arising out of California, where many interesting employment laws come out of. In California, what happened is there was an individual, Ms. Moriana, who was a sales representative for Viking River Cruises. And when she was hired, she was asked to sign an agreement that she would agree to arbitrate all disputes, both any disputes on an individual basis, and she also waived the right to bring any kind of class, collective, or what's called representative PAGA actions. And PAGA is the Private Attorney General Act in California. So she was asked to waive all of those in court and to only bring those via arbitration. So her employment ended, and she filed a PAGA action against Viking River Cruises, not only on her own behalf, asserting that she had not received her final paycheck in accordance with California law, but also on behalf of all the other employees who were allegedly, the company had allegedly violated their rights under the California Labor Code with regard to wage and hour issues. So Viking River Cruises remembered that there was this arbitration provision, and they moved to compel arbitration on her individual PAGA claims and to preclude her claims on behalf of the other employees. And the trial court in California denied the motion and basically said, no, that's not how it works here. And it wended its way up through the California courts, and ultimately the US Supreme Court granted review. So the Supreme Court, the US Supreme Court, reaffirmed and expanded its prior preemption precedents. So held on to AT&T Mobility and Epic Systems. And they held that while the FAA, the Federal Arbitration Act, does not permit California to impose a regime that the only way for parties to agree to arbitrate one kind of agreement, the individual agreement, is for them to also agree to arbitrate all the other kinds of agreement. So conditioning arbitration on allowing a claimant to seek remedies in arbitration on behalf of other employees was incompatible with the FAA, according to the Supreme Court. And the court further held that, so basically the court said, listen, this California law is preempted by the Federal Arbitration Act and cannot be enforced in this way. The Supreme Court also said that because California law doesn't provide a mechanism to be able to enable a court to adjudicate the non-individual, the group PAGA claims, once the individual claim has been committed to a separate proceeding, so that the lower court had to dismiss the non-individual claim. So basically it's a provision in PAGA that there's no way that you can say that you can bring individual claims in one place and group claims in another place. That just wasn't going to work. And so the lower court had to dismiss the plaintiff's non-individual, the group claims. It was a big win for employers in California. And as a result of this big win, we think that employers in California should examine their arbitration agreements and make sure to revise them to permit that you compel arbitration for the individual PAGA claims, and that they're enforceable or considered evaluated under the law. Now, there's a rub, of course, as there is always a rub with these kinds of cases. And part of the challenge is that it was that mechanism for not being able to enforce the two kinds of claims at once. And Justice Sotomayor said in her concurrence that, this is all, we think that we've gotten it right according to the law, but the California legislature is free to modify the scope of the statutory standing under PAGA within federal and constitutional limits. So there is a possibility that the state law might be amended in order to permit employees and to revise this so that there can be arbitration in both ways or different. Who knows what the California's legislature is going to provide. But we do think that employers, if you have agreements for individual arbitration, should be able to enforce those in California, at least for individual PAGA claims, and you should be able to dismiss any remaining non-individual PAGA claims, seeking penalties on behalf of the employees. So that's California and this recent Supreme Court case. But arbitration provisions are common, or at least not uncommon, throughout the country. So next slide, please. There are state and federal restrictions on arbitration agreements that are very interesting, and many have popped up just in the last couple of years. Most recently is what's called the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which is a federal law signed into law in March of 2022. And what this law, I don't like the term forced arbitration. We prefer mandatory arbitration. But what this law basically says is that employees have the option, if the claim is a claim of sexual assault or sex harassment, to bring their claims to court. So these arbitration agreements, if an employee signs an arbitration agreement with their employer, but brings a claim of sex harassment or has a claim of sex harassment, that arbitration agreement is not per se invalid, but the individual, the employee, does have the option of bringing that claim to court rather than arbitrating the claim. It remains to be determined whether there's an option to avoid pre-dispute arbitration or class or collective waiver, whether they would apply only to sexual assault or sex harassment claims, or to all the claims. It's just not clear on this law. The law is so new that it's hard to know. But it is clear that under this law, if an employee has a claim of sexual assault or sexual harassment, that person can bring that claim in court without regard to whether they've already signed an arbitration agreement with their employer. Similarly, a couple of the states, New York and Illinois, have enacted provisions where they talk about where they preempt, where they try to prohibit arbitration or limit arbitration. In Illinois, it's the Illinois Workplace Transparency Act. States that it cannot be a unilateral condition, so basically requiring an employee without any kind of negotiation that they must arbitrate a future claim is against public policy. In New York, an amendment to their law specifically prohibits an agreement for mandatory arbitration of any claim of discrimination or unless it's inconsistent with federal law. And that last provision is very important. It's entirely possible that both of these the New York and the Illinois law might be preempted by the Federal Arbitration Act, the FAA, because to the extent they're not covered by the ending forced arbitration of sexual assault and sexual harassment law, because they limit arbitration. And as the Supreme Court has previously told us, the FAA strongly enforces and encourages arbitration. And so one of the things that we suggest, if you want to have an arbitration agreement, is to make sure that your provision says that, adds a caveat that says, you agree to arbitrate to the extent consistent with and not preempted by federal law, or to the extent consistent with and not preempted by federal law, or inconsistent with the ending forced arbitration of sexual assault and sexual harassment act at your election. Adding that kind of language may be very helpful to ensure the enforceability of an arbitration provision. Next slide, please. So without regard whether you can enforce the arbitration agreement or not, it's also important, as Marcia said, with regard to non-competes, to think about, do you want to have an arbitration agreement at all? There are advantages to arbitration agreements or requiring your employees to arbitrate any disputes. It does increase the confidentiality. Arbitration is typically confidential, and federal court and state court proceedings are not. And this can also often be important, especially when there are disputes with executives, when there are non-compete disputes. This can be a key consideration. Arbitration tends to be a bit less adversarial than federal court. Typically, it's people who are more familiar with the situation, so they tend to be less at odds with each other. Often your arbitrator, who is chosen by both parties, agreed upon by both parties, often the arbitrator is a person with subject matter expertise, as opposed to a judge who may or may not have any expertise in your area. And as we saw with Viking River and PAGA, it can help you avoid representative litigation, class action, and collective action litigations. But not every case is appropriate for arbitration, especially as we noted, if there are restrictive covenants and there's third parties, someone who is soliciting your person, or if you are considering suing another employer for intentionally interfering with the restrictive covenant between you and your former employee. That's typically not appropriate for an arbitration proceeding. Arbitration can actually be more expensive than litigation, because in addition to paying your attorney's fees and experts and other sorts of fees, there's also an obligation to pay the arbitrator's cost, which may be split between the parties or may only be paid by one party. And sometimes arbitrators, because they want to get hired again and again, may split the difference, split the baby between the two parties. So we suggest that you consider whether arbitration is appropriate in all situations, if it is enforceable and not and something that is something that you care to do. So I'm going to move on now from arbitration. Next slide, please, to antitrust. And antitrust really is a new skill for HR lawyers, and it's not a skill that we often that we have a lot of subject matter expertise about. So that's why we're grateful to have with us one of our internal experts, Scott Perlman, who is going to help us understand what antitrust is and how it relates to human resources. So I'm going to ask Scott some questions, and I'm sure that his answers will be enlightening. So Scott, I've heard that the Department of Justice has been cracking down on non-solicitation and no hire agreements. Does this mean that our clients who are sellers in an M&A transaction should not agree to these kind of provisions in definitive agreements?
No, it doesn't mean that, but I should elaborate on that answer. If you could go to the next slide. So the Department of Justice and the Federal Trade Commission are very focused right now on using antitrust to challenge agreements that they believe restrict the ability of employees to move from one job to another, and also that have an adverse impact on their level of compensation. And they focused on two particular types of agreements. One are no poach agreements, where basically companies agree not to hire or solicit each other's employees, and wage fixing agreements, where companies agree to fix or limit wages or other term compensation. And these agreements can be per se illegal under both the federal antitrust statute, the Sherman Act, which prohibits unreasonable restraints of trade. And also pretty much every state has a statute that looks a lot like the Sherman Act, and the state law usually saying it'll be interpreted consistently with the Sherman Act. So when you have per se illegal activity under the Sherman Act, it can be prosecuted criminally. And the slide here outlines the penalties for both companies and individuals, which can include for individuals up to 10 years in jail. And the government is bringing, as I'll talk about in a minute, criminal cases challenging these type of agreements, including against individual executives. Now, these agreements can be written, they can be oral, but they also could be inferred from the parties' conduct. And an important distinction here is between naked agreements and ancillary agreements. So naked agreements are agreements that don't have any connection to plausibly pro-competitive activity. And basically what you're talking about is a standalone agreement by companies competing for the same types of employees to not compete or to agree on levels of compensation. Now that's as opposed to ancillary agreements. Ancillary agreements are agreements that may restrict, for instance, hiring or solicitation that are entered into in connection with a legitimate transaction, such as the sale of a business, like in your question. So if we can go to the next slide. There are a couple of examples here of criminal cases brought by the Justice Department in this area. So one of these cases was against DaVita, and it was brought against both the company and the CEO. They were both acquitted on all counts, and indeed, so far, the government has not been able to obtain any convictions in any of the cases that they brought in this area. However, there's one case where they're expecting to get a plea agreement. So that would be the first time they get any sort of conviction in this area, but they have pledged to, and I fully expect they're going to continue to pursue these types of cases. The second case listed here, Raytheon, a significant point here is that, as you see from the slide, the case also spurred some private litigation. It's very common, for instance, when the government brings a case against certain activity that you have follow-on private litigation. And that litigation can include class actions, as was the case here. And generally, these cases seek treble damages under the antitrust laws. So if you're talking about criminal penalties and treble damages, obviously the costs of entering into these agreements can be quite high if they violate the Sherman Act. So if we can go to the next slide. Okay, so here are some guidelines on avoiding criminal and civil liability for no poach agreements. And what I'm going to focus on is on the last point here, which really goes through Kim's question. So if these agreements are entered into in connection with a legitimate transaction, they're not per se illegal if they're necessary of the transaction happening, and if they're limited in scope in terms of things like the type of employees covered, the geography covered, if that's relevant, and also duration. So for instance, an agreement that may have a no solicit or no hire restriction for say a year or two, it's more likely to be viewed as being legitimate. If it's say 5 or 10 years, it's more difficult to justify. And really a key fact here is the buyer has a legitimate interest, for instance, in the sale of the business and not having the seller coming back a month later or whatever and start hiring back its former employees and devaluing the investment the buyer made from buying the business. But for instance, how long these agreements can last is a function of, does the buyer really have a legitimate interest in preventing that from happening after a certain point of time, given the industry, the types of employment, and so forth. Now, if an agreement meets these requirements, it's not per se illegal, but you're not totally out of the woods yet. It's evaluated under what's called the rule of reason. And the question there is whether it would have an actual anti-competitive effect, for instance, on wage levels. Would it suppress wages? And in most transactions, that's not going to be an issue. And generally, it only would be an issue if you had two companies that represented a significant percentage of the demand for these types of employees. So for instance, say that 30% or more, where it would be viewed as really a material restriction on the ability of employees in the market for their employment services to move around and get better wages. So if we can, I think that's kind of wraps it up on number one. So again, you want to look at whether if you're proposing or you're being asked to enter into these sorts of agreements in the context of a transaction, whether it meets these requirements that I touched on in point 5 on slide 32. So I think go ahead, Kim.
That's really helpful, Scott. So I want to follow up on one point that you talked about, wage agreements. In the context of a merger and acquisition, when I'm advising the seller, often the buyer wants to have wage information and wants the seller to provide in due diligence annual salaries, for example, for the top executives. Is that okay to provide in the context of an acquisition, or is that wage fixing?
It is not in and of itself wage fixing, but if you go to the next slide, I can give you a little bit of background. So, this slide provides some guidelines on avoiding entering into illegal agreements with respect to wage fixing. And by wage fixing, we're talking about salaries and also of any form of compensation. But it's quite common, obviously, in M&A transactions to have the buyer ask for wage information from the seller. It's not per se illegal to do that. However, you do have to be mindful of who on the buyer side is going to be able to see that information. Generally, the concern is that wage information, particularly for higher level executives, is viewed as competitively sensitive information. So you don't want people on the buyer side who set wages and compensation for those types of employees seeing that information. So it's okay to share it, but it should be shared in some restricted form. For instance, one way of doing it is to have a clean team where you put people on the clean team for the buyer who are not involved in setting the wages for these types of employees. They can see the information and they can prepare reports at a level of generality or abstraction that don't reveal the competitively sensitive details, but can be shared with people at the buyer who are not on the team. So you can exchange that information with appropriate restrictions.
So Scott, when we're not in a mergers and acquisition view, but what about sometimes we get called to see if a company can participate in salary surveys or even speak with their colleagues like at a conference about wages or salaries or agreeing not to solicit other companies' employees. What kind of guidelines do we give our antitrust people, our human resources folks regarding antitrust compliance.
Okay, well, I'll touch on surveys briefly first. It's perfectly legitimate to participate in a salary survey. The key point, though, is the survey should be done in a way so that it can't be reverse engineered to allow competitors to figure out what particular competitors were paying particular types of employees. And there are some guidelines that the government has provided on how to aggregate data to avoid that. In general, the survey should be compiled by a third party. The data should be historic, at least 3 months old. And there should be at least five sources of data for each data point. And no one company's data should constitute more than 25% of the data. And all that's designed, that's a safe harbor. If you're in it, you're in good shape. If you're outside of it, it's not necessarily a problem. But if you want to play it safe, the survey should at least meet those requirements. So before participating in a survey, you should be asking questions about whether it would meet those safe harbor requirements. As far as talking to your colleagues at a conference about what you pay your employees or about not soliciting, you should not do that. That could be evidence of a per se legal agreement to either fix wages or not solicit. And if somebody is asked to discuss that at a conference, they should immediately stop the conversation, say, I can't talk about this. If the conversation persists, they should leave, and they should immediately notify their legal department that that's taken place.
All right, next slide, please. And here we have, Scott and I have collaborated to provide some guidance to HR. And the primary guidance here is ask your legal department if there are situations where you're concerned about, from an HR perspective, concerned about recruiting or compensation queries that are coming in, participating in a survey, or conversations or requests that you're getting from your colleagues at other companies regarding non-solicit agreements or a discussion of wages or salaries. Well, thank you, Scott. That was really informative, and I learned a lot. But I think we're now, in order to keep us on time, we're now going to move on to pay transparency. Next slide.
Great. Thanks, Kim. So I'm going to switch gears here and talk about various laws that are designed to address pay disparities. The first set of laws that I'm going to discuss are pay transparency laws. Thank you. And so these are laws that require employers to disclose salary information for each position at some point during the hiring process. And as I'll talk about later, there are often some other triggers as to when this information needs to be disclosed. But we see here on the map, there are various state laws that have come into effect that require these disclosures. And I've read several articles that, that identify pay transparency laws as the hottest trend in equity pay legislation. So not only do we have the states where laws are currently in effect, there are several states where laws have already been passed and they'll be in effect starting in 2023. And New York also has a pending bill that everyone expects the governor to sign. So while I'll touch on some of the requirements of these laws in a bit, before I do, it's important to know that cities and counties are also getting in on the action. Next slide, please. For example, while there's still a pending bill in the state of New York City has already passed a law, as well as Westchester County, and those laws will go into effect in early November. And Ithaca has a law that is already in effect. And as you can also see from the slide, cities are active in enacting pay transparency laws in states where there's no law enacted or bill pending. So the example here is Ohio, where there's no state law in Ohio, but Cincinnati and Toledo have long had pay transparency laws. So you want to be mindful of the patchwork of state and local laws which may exist in the jurisdictions where you have employees. So I'm going to talk about, what do these what entities are covered by these laws and what do the laws require. Next slide, please. I'll go over some examples here. It's the example from California, which goes into effect in 2023. And all employers are required to provide, upon reasonable request, the pay scale to an employee for the position which the employee currently holds and to an applicant applying for a position. And for employers with 15 or more employees, the pay scale needs to be included in any kind of job posting. So there's no requirement that you have to have a job posting, but there's many reasons, business and legal, to have job postings. And so if you decide to have one and you have over 15 employees, you need to provide the pay scale information. Also, if you're an employer with 15 or more employees and you engage a third party to announce, post, publish, or make known a posting for you, the third party needs to include the pay scale in the job posting. And employers are always also required to maintain records of the job title and wage rate history for each employee for the duration of the employment, as well as 3 years after. And these records need to be available and open to inspection by the labor commissioner to determine if there is any kind of pattern of wage discrepancies. And the law provides that if an employer fails to keep adequate records, there's a rebuttable presumption in favor of an employee claiming that there's a violation. Parts of the California law also that you may already be familiar with from other laws as well deals with asking for pay history information. So under the law, an employer is prohibited from directly or indirectly seeking salary history information from an applicant or relying on salary history information from an applicant as a factor in determining whether to make an offer or what salary to offer an applicant. But on the flip side, there is no prohibition from an applicant voluntarily disclosing such information. And then if it's voluntarily disclosed, the law does not prohibit an employer from considering or relying on that voluntarily disclosed wage information in determining the salary. And again, nothing prohibits an employer from asking an applicant about their wage expectation. A little nuance there. So these are some of the highlights of the California law. I'll turn to some highlights of the other laws in effect here on this slide. We see, first I'll discuss coverage. So we see from California, the law applies to all employers, and there are different obligations if you have 15 or more employees. In Colorado, the law applies to all employers that employ at least one employee in Colorado, and then all employees of those employers. And, so this includes out-of-state employers with Colorado employees. In New York City, the law employs to companies with 4 or more employees, as long as one of the employees works in New York City. Again, you should check whether you're a covered employer in the jurisdictions where you have employees. So, as you can see, from this slide, the requirement and the triggers for when you need to disclose pay information differ. Sometimes it's, in each of the job postings. Sometimes it's when you extend an offer. Sometimes it's upon request. Sometimes it's after an interview. Sometimes it's after you've made an offer. I'll drill down on some examples with regard to Colorado. Which is one of the strictest laws. So these apply to each job posting, which includes electronic and hard copy communications that an employer has a job opening. Pay range is basically the highest and lowest pay that an employer believes it might pay for a particular job, depending on the circumstances such as qualifications, employer finances, and other operational considerations. Colorado has a nice set of FAQs that provides guidance on the Colorado laws. And some of the guidance includes things like you say, well, what pay range? I don't understand. What can I put? What do I have to put in the posting? So this guidance provides that pay ranges can't be open-ended on either end. So for example, in Colorado, you can't say for this job, the salary range is $30,000 and up because that's open on the back end. Or you can't say this job pays up to $60,000 because that's open on the front end. And you also can't provide, let's say, for example, huge ranges. Let's say, the range for individuals for openings in your company, range from janitors to accountants. You can't put things in that say, the range is between $30,000 and $100,000. You'll see here that Colorado also requires disclosure about benefits. With regard to benefits information, there has to be a general description about bonuses, commissions, and other compensation. And benefits that must be generally described include healthcare, retirement benefits, paid time off, any kind of tax reportable benefits. But you don't need to include like minor perks or any dollar value of the benefits. And the guidance also provides that you can't provide catch-all language, such as, we provide healthcare benefits, etc., or healthcare benefits and more. Things like that would be in violation of the law. And one thing to keep in mind also that these laws, while they require disclosure, for example, in Colorado, they don't prohibit an employer from ultimately offering more or less than the posted range. What's required is that at the time of the posting, the employer genuinely believed that this range was what it was willing to pay the candidate to come to the job. You'll see here also one of the unique items. So Washington, used to be after you've made an offer, but there was an amendment starting in 2023. It becomes in all of the job postings. And you'll also see that in New York City, some unique features is it's not only job postings. And again, some of these laws also have these elements. So this is not an exhaustive list. But some of the items, it might be that you would have to provide pay ranges for a promotion or a transfer opportunity, as well as the disclosure laws applies to information regarding independent contractors, interns, basically any individual who is covered by the New York human rights law, which for those of you who practice in the space are aware that they have a very broad definition of who the human rights law applies to. So the takeaway for this information is again that there's a lot of different laws out there, and they differ with regard to coverage, with regard to triggering events, and with regard to obligations. So be mindful of those obligations for compliance purposes. Next slide, please. I'm running short of time, so these are penalties associated with the pay transparency laws. You'll get this slide later, but they really range from small amounts to really high amounts in New York City. Next slide, please. I'm going to switch here and touch base very quickly on data reporting laws. And these are laws where employers are required to report data to various government agencies. There are certain laws in California, Illinois, and Minnesota. These here are summaries of the laws in California and in Illinois. Generally, they apply to private employers with 100 or more employees, and they require reporting on pay data by race, ethnicity, and sex, with regard to job categories, with regard to pay ranges, sometimes hours worked. In California, they're required every year. In Illinois, the reporting will start in 2024 and be required every 2 years thereafter. California, it's important that it's 100 or more employees with at least one employee in California. So while the law has been in effect for a few years, there were a lot of out-of-state employers or employers that did not have headquarters in California that were not in compliance with this law. Some employers got extensions. Extensions, I understand, are no longer being granted. The guidance is to get your filing in as soon as possible, so they're not actions by the department to get you in compliance, at which case that you would be responsible potentially for the costs to get you in compliance. And as well, you can see here that each of the laws has various penalties. I want to focus some nuances in the Illinois law. They talk about the equal pay registration certificate. And next slide, please. Various items which need to be filed in Illinois, again, starting in 2024, is your recent EEO-1 report, then a list of employees separated by gender, race, ethnicity in the EEO-1 report, plus, again, wage and hours worked information, and then a statement. And the statement needs to be signed by a corporate officer, a legal counsel, or an authorized agent of the business. And they need to certify that the company is in compliance with these various federal laws, that the average compensation for female and minority attorneys are not consistently below average for male and non-minorities, that they don't restrict the employees of one sex from certain job classifications and don't make decisions on promotion or retention with regard to sex, that the wage and any wage and benefit disparities are corrected when identified, the frequency in which an employer evaluates the compliance, and what are the methods that the company used to set wage and benefits. So again, this is a lot of information that needs to be attested to. So very important to know the obligations and start getting your ducks in a row to get yourself compliant. So that'll turn to the next slide. So actions, I'm sorry. So those were the state laws. Again, there's more coming with regard to federal actions. Biden administration it has had over 90 different federal agencies publish equity action plans. The EEOC in April of 2002 recently released theirs, and one of their goals is to improve data collection and reporting, which includes pay data recording analysis. And there's basically been commentary from the EEOC commissioner about watch it, it's coming. That's the component 2 of the EEO-1. Some of you may be familiar with this a few years ago. During the Obama administration, this was a requirement with the EEO-1 report to also include wage information. This went away, but it's coming back, and that's the trend. And so next slide. What to do? Things to consider. Primarily is first conducting an audit. Do you know what's going on across your organization with regard to pay? And this will allow you to be proactive in addressing any kind of gaps when it comes to reporting to the government, as well as just publishing those pay scales when you're looking for applicants using objective criteria. Little asterisk there is, again, being careful about when you can use pay history and when you cannot. Consider using a uniform or centralized processes and decision-making with regard to setting wages. Make sure you maintain records, make sure you train individuals, your HR staff, your supervisors, anybody that's involved in compensation decisions. And then preparing to address employee relations issues. Right now that this information is out there, to the extent that there are any kind of gaps or anything like that, there's going to be questions. So again, the best way is to have your audit ahead of time, so you get your ducks in a row before employees might see that they are subject to disparities, but also training individuals on how to respond to employees that do have questions about this.